We already defined law as a system of rules. Now let's see what are the sources of these legal rules. From where do they come? The importance of this topic is that legal rules grant us individual rights. I mean, our rights, the rights that we enjoy, are granted to us by the legal rules. And these legal rules must come from competent sources, from recognized sources. In legal books and law books, you may find many classifications of legal sources, of sources of law. Here we are going to distinguish between direct sources and indirect sources. What do I mean by that? Direct sources are sources that are competent to produce legal rules that are mandatory immediately. That are mandatory by the mere fact they were produced or issued by the source. Whereas indirect sources are sources that are not legally competent to create rule, to directly create a rule. However, practically, they will end up by creating rules in an informal way, if you want. Okay, so for instance, let's start with the direct sources. Written laws. First of all, what do we mean by law? We already used this term many times, but in this context, in this particular context, right, when we are talking of written laws and not of law in general, law may have a broad meaning, a large meaning, the meaning we just saw when we defined law, the system of legal rules coming from all sources of law. In Arabic, we may speak of al-qanun in a general sense. In French, le droit, also in a general sense. But law may also have a very narrow meaning, a very technical meaning. In Arabic, then we will speak of al-amal al-tashri' or al-tashri'. In French, we'll speak about la législation, l'acte législatif. And these are the written laws issued by the legislator specifically, by the parliament. But law can also have a middle meaning, a meaning which is in between these two extremes. So written laws are the legal rules issued by competent state authorities having this power to create rules. Mainly the parliament, but as we said, also sometimes the executive. So we can count among these written laws, first of all, the constitution, al-Dastur, which is the higher source, the higher norm, the higher set of legal rules. Then we have legislative acts, meaning law understood in a narrow meaning, acts of the legislator. And then we have the administrative acts, written laws or written rules coming from the executive branch, such as decrees, al-marasim, al-qararat, al-ta'amim, ila akhirah. Okay? Here's a list of certain laws we have in Lebanon. Next, we have customs. Now, the difference between customs and written law is that, first of all, custom is not necessarily written. Mostly, customs are not written. Customs are not a top-down procedure. And it's not the legislator telling the community, these are the rules you have to obey. Customs are rather a bottom-up mechanism. Because customs, al-araf, sometimes also in Arabic calls them al-adat, they are practices in a certain field, common practices in a certain field that are followed continuously for a period of time. So the element of being commonly practiced and the element of time, but also a psychological element that they must be considered as obligatory by the interested people. All these elements will create a custom that will become a rule of law, a mandatory rule of law. We can find customs in business law, we can find them in international law or in constitutional law. For example, the constitutional rules that the President of the Republic in Lebanon must be a Maronite, and the Speaker of the Parliament must be a Shia, and that the President of the Council of Ministers must be a Sunnah. These rules are not written in the Constitution. They are constitutional customs. So they have become mandatory, obligatory, because they are customs. They are practices respected continuously, at least since 1943, and considered as obligatory by the Lebanese community in general. These two sources we mentioned are the direct sources. But we also have indirect sources, judicial decisions. Here we can distinguish between a rule and a judgment. A rule must be general. Okay, a rule is written or stated, a rule is usually stated in a general fashion, in a general manner. They do not mention individuals, they don't mention general qualities or qualifications or general situations. Now, this rule, when it must be applied to an individual, it will be applied via the judiciary branch through a judgment or via judgment. So a judgment usually concerns one individual, a determined individual. A judgment is not written in general term. And the rule would be whoever steals goes to jail. A judgment would be X stole, therefore X will go to jail. I hope you can see the difference between these two. A rule does not mention individuals, whereas a judgment is centered around an individual or targets an individual. So in general, judiciary judgments or judicial decisions, since they target a specified individual, cannot be considered as rules because they lack the generality of a rule. However, when after time and concerning the same kind of issues, judges are applying the same principle, this principle may become itself a part of law, especially if there's no written law about the topic. So with time, judicial decisions may become principles of law that are considered as mandatory. In Arabic, we speak of ijtihad. On this slide, you can find the hierarchy of civil courts in Lebanon, al-Mahakim al-Madaniyya, noting that the purpose of the Court of Cassation is to unify interpretation of law. And you can find first-degree courts or tribunals in all muhafazat, and you can find unique judging, al-Qadi al-Munfarid, in all qada. Courts of appeal, we can find them on the muhafazat level, but there's only one court of cassation in Lebanon, in Beirut. As for the criminal courts hierarchy, you can find it on this slide and this slide as well. Finally, the fourth source we are going to tackle, which is the second indirect source, is doctrine. What is doctrine? By doctrine, in legal studies, we mean the scholarly work, the scholarly research, the scholarly literature and scholarly production made by scholars who are working on positive laws in it, to try to explain, to analyze, to synthesize positive law. These scholars may be university professors, they may be professionals such as lawyers, judges. They are working in an academic way on laws, trying to explain them, to analyze them, etc. The whole of this scholarly work is considered as doctrine. Doctrine also may sometimes create laws or at least influence the way law is being understood or interpreted. So it is an indirect source. It cannot create legal rules. It may influence how the legislator will create new rules, or how the judiciary will interpret legal rules. In Arabic, we call it al-fiqh. Now, please note that Lebanon is considered as part of the Romano-Germanic tradition. So, universally, or in comparative terms, we have different regimes, we have different traditions, and sources of legal rules will differ in all these traditions. Okay, this is speaking in comparative terms. The most important traditions in comparative law are, from one side, the Romano-Germanic systems, mostly France and Germany, but also Italy, Switzerland, Spain, Latin America, and Lebanon. And the other main tradition is the common law tradition, the Anglo-Saxon tradition, UK, United States of America, Australia, etc. We can also find religious law systems as well. And when it comes to Lebanon, Lebanon is a mixed system because in general we belong to the Romano-Germanic family. We are influenced by France. Lebanese law is very much influenced by French law, but we still have a room for religious law, especially in the personal status system, personal status field, as we will see later on in this course. Okay? Now, the existence of difference between systems is also reflected in the sources, in the main sources of law, as we will see in the next video. So, in the Romano-Germanic system, sometimes also called the civil law system, such as in France, Germany, Italy, Spain, and also Lebanon, the main source of law is legislation, meaning the legislator, the parliament. But you also have secondary sources, such as customs, judgments, doctrine, etc. In Anglo-Saxon systems or in common law systems, such as United States or United Kingdom, the main source of law are judicial precedents, meaning judgments made by courts, which is quite different from our system. They do have statutes or laws, and they call laws statutes. However, the impact of these laws and the domain of these laws is quite limited when compared to judicial precedents, considered as the main source of law in these countries.